Okay. All right, so here we go. I'm Scott Fulton, president of the Environmental Law Institute, and it's my pleasure to welcome Ted Garrett today to reflect on his remarkable career as one of the pioneers of environmental law. This interview is one of 26 in the Institute's oral history series that's posted for public viewing on our website. Ted grew up in Connecticut, where as a boy he was interested in science, space exploration, and building rockets and transistors. He graduated from Yale with a degree in physics and philosophy and from Columbia Law School. He then clerked for 2 federal judges, including U.S. Supreme Court Chief Justice Warren Burger, and also served as a special assistant to William Rehnquist, who headed the Office of Legal Counsel in the Justice Department, and later became Chief Justice himself. In 1971, Ted joined the Washington, D.C. firm of Covington and Burling, just when environmental activism and major federal legislation were creating big new challenges for public officials and private industry and business. At Covington, Ted became a respected expert and counsel on practically all aspects of environmental law. He has represented major multinational companies from every sector of the economy, and as a skilled advocate has had a significant impact on the content of environmental law and regulation. Ted received the Who's Who Legal Lifetime Achievement Award in 2015, among other accolades, and remains active as senior counsel at the firm. Throughout his career, he has also been a leader in many professional organizations, including service as the chair of the Environmental Bar Association section on environment, energy, and resources, and as a regent of the American College of Environmental Lawyers, an organization composed of prominent practitioners in the field. At ACOEL, Ted chairs a rapid response committee working to provide white papers and training programs on timely topics and to involve other ACOEL members in providing blogs on fast-breaking issues. Ted, I know I've missed a few things that you might want to emphasize about your background, so let's take a moment at the beginning and create the space for some observations on that.
Well, thank you. I'm pleased to be here today, and thank you for that nice introduction. I thought it might be worthwhile or interesting to recount how I became an environmental lawyer. I was, as you mentioned, interested in science at an early age, but in college I took a left turn and became a lawyer. And however, I've found throughout my career that I spent a lot of time working with scientists, so I've, by osmosis, am enjoying my scientific interests. One of the first cases that I handled as an associate coming off a Supreme Court clerkship at Covington involved the aftermath of the Santa Barbara oil spill in California. That was quite a catastrophic event in California, and the blowout occurred on a Union Oil Company tract, after which the government froze drilling in the Santa Barbara Channel. Our client was Sun Oil Company. They came to us because they had paid some $30 million for a lease, and the government was telling them they couldn't drill. After the Union blowout, the Interior Department upgraded drilling procedures to make sure that that kind of event couldn't happen again. I won't go into the technical details, but when those procedures were implemented, Sun sort of renewed its application for a drilling platform, and it was denied. And so after considering various options, we advised the client that you're never going to get mandamus against the federal government. So we went to the Court of Claims to get compensation because the company had paid, in the vernacular, $30 million for a hunting license, and the government was telling them they couldn't hunt. What we discovered, we went through discovery, and in the course of that found newspaper clippings, and then deposed a reporter who testified, as he had reported, that President Nixon, in a campaign swing through California, announced that although Rogers Morton announced the decision to deny the platform, that I, Richard Nixon, made the decision. We then requested White House documents. Nixon asserted executive privilege. The trial judge decided that this was above his pay grade, so he referred it to the full Court of Claims en banc. 2 weeks before oral argument, which the partner in charge, Henry Saylor, a brilliant antitrust lawyer, told me to do because he said it was my case, Nixon resigned under threat of impeachment. He had not yet been pardoned by President Ford, so criminal charges were possible. And of course, with Rosemary Woods and documents, the whole issue of documents, White House documents, was very sensitive. So I argued the case. Nixon's lawyers made an appearance claiming that he was still entitled to executive privilege. And the Court of Claims en banc eventually said we were entitled to the documents, that executive privilege was not absolute. Fast forward, we prevailed on summary judgment on the merits. I think that the court was troubled by the fact that there was White House interference in the decision for apparently political reasons. We eventually got through a damage phase. I learned a lot about movement of underground fluids because Sun had a claim of drainage in addition to the lease payments. The oil industry was way ahead of everybody else in terms of that kind of underground monitoring, which later became very useful to me when I started handling Superfund cases. But basically, that's how I became an environmental lawyer. That was the first major environmental case at the firm. It was early in the 70s, and as you know, the Clean Air Act and Clean Water Act were passed early in the 70s. The government started enacting regulations, and clients came to the firm for advice on how to deal with these issues, and I was the guy.
Wow, well, that's a terrific story. And do you see any shadows from that earlier experience kind of casting forward to today, as we're once again dealing with the White House that is interested in asserting executive authority around the question of environment and related issues?
Well, it's hard to tell. In that particular case, there was an indication that there were sort of political reasons for the decision. And the discovery had shown that at all levels of the Interior Department, up until the final decision, the staff was recommending approval, that the platform complied with regulations. And so there was a strong sort of odor about whether the decision was made for political reasons, and the president, in fact, had indicated that he made the decision. I think that any president needs to be careful about crossing lines.
Well, I may bring us back around to the current times in a bit, but let's reflect a little bit more on the trajectory of your career. And I guess the question. You found yourself an environmental practitioner at the early stages of the country's experience with the environmental question. Have you found it to be a rewarding area of law practice, and how has the practice changed, you think, over the course of your career?
It's been very rewarding and gratifying. Environmental law really lies kind of at the intersection of science and policy. And law, and so, and it developed starting in the early 70s. What was fascinating about that time is that there was a very strong national dialogue on a whole series of issues. You had the Vietnam War protests, you had a lot of concern about race relations and justice, and the environmental movement. You had Earth Day, where millions of people demonstrated in favor of the environment. And so across political parties, you had a consensus that something needed to be done in those various areas, and a blossoming of statutes that I referred to earlier, the Clean Air Act, Clean Water Act, RCRA in '76, Superfund. EPA was tasked with administering these statutes, EPA, like private practitioners and NGOs, were making things up as they went along because nobody knew how to implement these laws. You had to read them and exercise policy and scientific and legal judgment going forward. Some of the early environmental cases I handled involved EPA approval of state implementation plans. We represented Appalachian Power Company at the time. EPA had approved implementation plans for Virginia, West Virginia, and Indiana. No public process. The state submitted the plan. EPA looked at it, said these look fine, and approved them. And so we brought lawsuits in the Fourth Circuit and the Sixth Circuit, arguing that there's something called the Administrative Procedure Act, and the public's entitled to notice and an opportunity for comment. And the courts agreed with us. And EPA, of course, changed its procedures, but it sort of illustrates the fact that people were struggling with how to implement these new laws, and it was a learning experience. One matter that I found very gratifying had to do with the spill regulations under Section 311 of the Clean Water Act, and I think it illustrates at the highest levels of government and practice an ability to be adversaries but also to work together. Section 311 of the Clean Water Act directed EPA to establish regulations for spills that would be deemed unlawful if they were discharged in quantities that were hazardous under various times, circumstances, and conditions. I'm paraphrasing the statute from memory. EPA struggled with that statute, wanted to establish the hazardous quantities, but concluded that it would be too complicated to decide what level would be hazardous in a small pond or a lake or various sized bodies of water. So instead, they selected 5 different weights of substances and ranked a variety of substances based on relative hazard and assigned hazardous quantities to the substances based on those 5 categories. Well, those regulations came out and they were effective, I think, in 30 days under the Administrative Procedure Act. And our clients in the chemical industry, but other industries joined us in a lawsuit after that, realized that they had received Clean Water Act NPDES permits after sort of a careful review of their discharges that allowed for discharges in quantities in excess of the Section 311 spill regulations. Arguably, Congress intended the spill regulations to cover sort of uncontrolled spills rather than those through a treatment system, but the statute really wasn't entirely clear on that score. And so we went to a district court in Louisiana, where a lot of chemical industries were located, and asked for a temporary restraining order and then a permanent injunction, arguing that the regulations were contrary to the statute. EPA hadn't gone through the process that the statute contemplated in terms of considering all the times and circumstances of discharge. So we won, and EPA filed a notice of appeal to the Fifth Circuit, but it wasn't very optimistic, apparently, about its chances of success. And this is where the interesting part of the story comes. Tom Jorling came to us and said, look, we really want to be able to regulate spills. This would set us back quite a long time if we can't do this. Is there some way that we can work something out? And I talked to my clients and talked to him and said, look, we're really concerned about these NPDES discharges, that if you're talking about an uncontrolled spill, not part of a treatment system that's been federally reviewed, we don't have any problem with that. Your regulations arguably aren't exactly what Congress had in mind, but it's rough justice, and if you can exempt NPDES discharges, we would go along with that. So what we did, working with the EPA Office of Water, a rider to an appropriations bill was crafted. It went through, Senator Muskie held very quick hearings on it. Our clients didn't testify, but Congress knew that there was no industry opposition. And
hang on a second.
Should we wait for that to?
Yeah, let's just let that pass. And
That's pretty loud.
I'm thinking
Maybe I ought to go back
why
a
don't you go
sentence or
back
two.
to starting to talk about the rider process and Muskie as soon as the siren's going. We get a lot of that these
Yeah.
days. A lot of motorcades coming through here, though. That didn't sound like a motorcade.
Let me take
Okay.
Let me take
Anytime you're ready.
The government filed a notice of appeal of the district court's decision, but apparently wasn't wildly optimistic about its chances of success. So Tom Jorling came to us and said, we really would like to have these regulations be in place. We understand you're concerned about NPDES discharges. Is there some compromise we can work out? And on behalf of our clients, we said that the industry would be fine with the hazardous substance regulations remaining in place as opposed to what are normally considered to be spills, uncontrolled spills to the environment, as long as you exempt discharges from treatment systems that have gone through public review and an NPDES permit process. We agreed that that was a sensible compromise. A rider was drafted to an appropriations bill that was then before Congress. And there were very quick hearings scheduled. The industry did not testify, but EPA did. Senator Muskie handled them on the Senate side, I recall. I forget who handled it on the House side. But that was very quickly adopted within a matter of weeks. And so we now have the federally permitted release exemption to the Clean Water Act. A footnote is that when Superfund was enacted, there was a similar exemption enacted into the Superfund statute with essentially the same language. And that was the history of that. And I found it, and then after all that took place, I received a very nice letter from Tom Jorling thanking me for my statesmanship and leadership on the issue. And so it's unusual, I guess, for a lawyer to bring a lawsuit against EPA to prevail, beat them in court, and then be thanked. But at that time, I think that there was a spirit among NGOs and EPA and industry to try to work out problems. I also recall being involved in a number of national regulations, for example, the PSD regulations and the NPDES Clean Water Act regulations. In both cases, EPA went through notice and comment. There were still issues. There were lawsuits filed. And the agency was willing to sit down with folks on both sides, both environmental groups and industry, and ask whether some changes could be made that would obviate some or most of the issues in litigation. And EPA took voluntary remands of those cases, made changes, and I think the result was an improvement in the regulations. And those were times when people were less polarized, perhaps, and more willing to compromise. But I think it was very salutary.
Yeah, you've had a window into the
It's coming again.
Sounds like a fire event or something over there. The question I'm going to ask you is about the changes in the business community's orientation to environmental expectations and environmental requirements, really from the early days to now, how you've seen that evolution. You've had a window into the business community's response to ever increasing expectations regarding environmental performance as reflected in the environmental statutes that came online and the like. But can you comment on the progression, if you've seen the progression, of thought in the business community about how environment is factored into business decision-making over this time?
I'd be happy to. I think in some of the early years, there was a lot of uncertainty about the impact of environmental regulations. And for example, when ambient air standards are established, the rubber really doesn't hit the road until their state implementation plans. And so people really had difficulty understanding what the impact would be. And because the regulations and the statutes were new, both the industry community and environmental groups were pretty active in bringing lawsuits. The EPA was receptive to requests for increased flexibility. Some of the matters that I handled were, a number of them, were situations where we intervened on the side of EPA. For example, under the Water Act, EPA was charged with setting technology-based standards for industries based on what was achievable. And the industry had taken the position that it ought to be possible in a permit proceeding for a company to show that its facility was different from the ones that were dealt with in the regulations and achieve a variance reflecting what could be achieved. The chemical industry in particular was concerned about that because a lot of chemical plants are really sort of unique based on particular specialty products that they may produce. And EPA established what's called a fundamentally different factors variance, which was challenged by environmental groups, and we had intervened on the side of EPA trying to defend that. I actually argued along with EPA in the Supreme Court on that in a case in the 1980s, and the court upheld that. Similarly, there was something called the bubble concept under the Clean Air Act. Bubble is sort of an odd name, but the notion was that rather than requiring a company to go through PSD review where there was a significant increase for a particular piece of equipment, that what you would do is look at the plant as a whole, and if the company could achieve significant reductions elsewhere to offset the increases for that piece of equipment, in other words, looking at the whole facility as though it was under a bubble, then you could avoid some of the requirements of PSD review. That was also challenged by environmental groups and ultimately was upheld in the DC Circuit and the Supreme Court, and we had intervened and argued on behalf of EPA. So there was a lot of pulling and tugging. EPA always finds itself in the middle on these kinds of issues with either one side or the other in opposition, sometimes both sides in opposition, and tries its best to carve out a middle ground. What I have seen over the years, though, is that, and I think it's partly as a result of public pressure, partly as a result of one of the successes of EPA policy, which is monitoring, reporting, and disclosure. There's a lot more transparency now than there was previously about what companies are doing in terms of releases to the environment, air, water, and so forth. We have the TRI list. And I think as a result, companies are much more sensitive to reputational issues. And it's, this is something that grew over time, but it's very commonplace now for companies to have vice presidents in charge of environment, health, and safety reporting to the highest levels of the company, to the CEO and to the board. Companies have environmental statements of policy, environmental management systems. Corporations increasingly are global in nature and have as a matter of company policy that they're not going to reduce their vigilance or environmental programs in countries that have standards that are weaker than others. They want to have sort of a global footprint and a global environmental policy, which is very salutary. And I think that the establishment and pervasiveness of those kinds of corporate policies will provide a certain kind of inertia against perhaps year to year or administration to administration changes in policies, because I don't think companies are going to be turning on a dime. We've also seen a lot of activity on the part of states. Of course, now we have red states and blue states, but states have delegated authority, they have regulations in place, and Some states have been much more progressive than others. States like California adopting policies and regulations more stringent than the federal government may require in some areas. But that also adds a certain break and a kind of inertia against backsliding, if you will.
You'd mentioned some of the factors that have influenced business behaviors over time. How do you see enforcement, both by the government but also citizen-based enforcement, as having contributed to some of the shifts in thinking in the regulated community?
Citizen enforcement has been with us since the air and water statutes and RECO were first established. They're not as extensive, perhaps, as enforcement by EPA in the states, but it's always an issue, and I think it's something that company managements and environmental personnel have in the background in terms of the need to comply. You can perhaps not take too much comfort from the fact that enforcement budgets may be cut if there are active citizen groups that are able to enforce the law. So I think that perhaps subconsciously it helps to influence corporate behavior, although I think that most companies have kind of gone beyond that now, and for its own sake, they just think that for reputational reasons, it's just something that they think they need to do as good citizens.
Yeah. Have you seen a change in your practice at all in keeping with that trend line, this desire on the part of companies to protect the reputational interests through kind of aggressive internal regimes for managing compliance, but also managing against their social policies and the like? Has that influenced your practice? I mean, do you find yourself getting drawn into that conversation with clients?
Yes, I've been involved in board of directors level reviews of corporate practices. I had one client that went through an interesting sort of internal debate about whether there was a particular product, I won't mention the name, that they wanted to continue manufacturing because it had been the subject of various lawsuits by people alleging health impacts and so forth. And they went through a fair amount of soul searching with me as counsel and also with outside health expert to decide whether it was a situation where third and fourth parties were using the product. It wasn't something that they were directly doing, but and maybe using it improperly, but for reputational reasons, whether they wanted to continue doing that. And ultimately, they ended up selling a division of the company. And it's an illustration of the kind of thinking that companies increasingly do in this area.
You had mentioned the opportunities for innovation through collaboration, and how sometimes these innovations become continuing fixtures in the legal landscape, like the federally permitted release exemption we talked about before. What do you see as the pros and cons of a litigated outcome as opposed to an outcome arrived at through compromise? And do you think we've kind of optimized the technique of alternative dispute resolution at this point, or do we still have a ways to go in finding alternatives to litigation for solving problems?
Both. I think that where rulemaking is concerned, I think that EPA solicits public comments, they make decisions, and often parties on one side, sometimes both sides are unsatisfied, and perhaps the only way to resolve it is to go to court. I think part of the answer to your question depends on the interest and willingness on the part of the agency to engage in a discussion and compromise. One area that you may probably know about has to do with the EPA CAFE standards for automobiles. That was brought about by the Obama administration White House office calling together the auto companies and seeing if they could agree on a program. Without litigation, it was very successful. It was one of the legs of the effort to deal with climate change issues. The other leg was the Clean Power Plan. And as you know, that's been very controversial. It's been challenged in the courts. This administration has indicated a desire to revisit that, and it looks like that's going in a different direction. There'll probably there's pending litigation. There'll probably be more litigation concerning that rule before all the dust settles. Whether there'll be an interest on the part of the administration to try to reach a compromise, I don't know. Sometimes it takes judicial action to provide a climate in which discussions are possible. There are some situations where litigation may be sort of the only option. One interesting case that I handled had to do with Superfund liability as applied to banks. As you know, Superfund provides for joint and several liability. EPA and the government traditionally have sued a relatively small number of parties for reasons of economy and efficiency, leaving it to the defendants to bring in third parties for contribution. And as the Superfund process unfolded and more sites were being addressed, banks found themselves being drawn into Superfund litigation as third parties on the basis of holding security interests in property. The statute provides that current and owners, as well as former owners at the time of disposal, are sort of jointly and severally liable, and banks looked at that as a situation where if they foreclose and exercise their security interest, they're liable under Superfund as an owner, potentially. Alternatively, if they refrain from foreclosing because they're concerned about potential liability, then they've essentially written off a security interest. And so they saw it as an untenable situation. So they went to EPA and said, this is inappropriate, and EPA responded by enacting a regulation exempting banks from liability under Superfund if their only interest in property was a security interest. Well, we represented industry clients who thought that Congress ought to be looking at the Superfund statute and making some mid-course corrections. And perhaps that was one of them, but if a correction were to be made, it ought to be made by Congress, not by EPA, just picking winners and losers. And so we went to court, and unlike most judicial challenges to regulations where it's a question of whether some of the refinements of a regulation match the statute, what we argued is that EPA had no authority in this area at all, that the statute defined who the liable parties were, that statute could be interpreted by courts in individual cases, that it was up to the court to decide who was liable. And by EPA making a pronouncement of that kind, they were infringing on the prerogatives of the court. They were infringing on prerogatives of states, which are allowed by statute to enforce Superfund, and perhaps private citizens. And the court agreed with us and held that EPA just didn't have authority. They had claimed that there's general authority under the statute to do what's necessary to implement the law, and the court had no problem rejecting that argument. So the end of the story is that EPA did go to Congress, and Congress did amend the statute to provide for lender liability, but I and my clients took some satisfaction that it was done the right way. That was a situation where that was probably the only way that issue could be resolved, is through litigation.
Right. Was that in the SARA amendments, the lender liability?
Yes.
Have you found over the years that your practice has moved increasingly in the direction of international environmental issues as your client base has become more involved internationally?
Yes, it has. We do a fair amount of work with the EU that has a regime that's quite different. I mean, they regulate electronic waste. They're more concerned about products traditionally than we have been in the United States. The U.S. model has tended to regulate releases and waste sort of after they're produced. The Europeans have more of a precautionary sensibility and are more concerned about regulation beforehand. And so we have a Brussels office, and to some extent in London, that does quite a bit of work with EU issues.
In our current moment, we're 2 months into the administration of President Donald Trump. Regulatory reform is very much in the air. We have the President's executive order recently issued directing that for every new regulation, 2 must be taken down, and now we have a budget blueprint that contemplates a large reduction in EPA's budget. What's your take on all this that's unfolding before us now, or your reactions as someone who's been in the United States environmental drama, if you will, from the very beginning?
I have a long view of these issues. I was practicing environmental law during the Reagan years, and you may remember that the White House at that time had a desire to decrease regulation, and they had appointed Ann Gorsuch, the mother of the current Supreme Court appointee, turns out, and Rita Lavelle headed the Superfund program. There was a lot of controversy about EPA's efforts at that time to be receptive to industry overtures to reduce environmental regulation, to the point where there was an indictment and resignations under a cloud. And we recovered from that. And we may be in another situation like that, where during the Obama years there was EPA was very active, and we now have a different party in power in the White House and in Congress, and they're going to, by all indications, propose some trimming back. And they've already indicated some desires to look at waters of the United States, which has been controversial ever since the Rapanos decision in the Supreme Court. Unfortunately, the Supreme Court didn't give us clear guidance on that issue with a 4-4-1 decision. And the last administration interpreted the Supreme Court's decision one way, and EPA has been asked to take another look at that. They've indicated a desire to take another look at the CAFE standards that I mentioned earlier for automobiles, and the Clean Power Plan. I think that there'll be the normal political process. There are going to be folks who support those kinds of changes. There are going to be people on the other side who oppose it. One of the things that EPA will need to address is the legal requirements for dealing with issues. You can't just wave a magic wand and change regulations. You need to go through a rulemaking process. And so if changes are to be made, they'll have to be done through that process. It'll have to be justified on an administrative record. And ultimately, if the past is prologue, there'll be litigation. And ultimately, the courts will have to decide whether any changes that are made are justified by the facts and by the statute. So that process will evolve, and we'll see how it comes out. It's pretty early to try to predict what the outcome would be. One thing I would comment on, though, is that I mentioned earlier that in the 70s and 80s, early 80s, there was a lot of public activism and involvement on a variety of issues, including environmental issues. And I think it would be healthy to have more public discourse on environmental issues. I expect that if you were to ask the average person, do you want clean air, do you want clean water, the answer would be a resounding yes. But those issues tend to get drowned out or not paid much attention to. I think it would be salutary if the public were engaged on these issues, so that decision makers in Congress and in the administration would have a better reading of what the public wanted.
How do you counsel your clients through a period of change like this? You also encourage them to take the long view, and what does that mean in practical terms for them, in terms of how they respond or realign their thinking to the current reality?
I do encourage clients to take the long view, and I think most of them do. As I say, that they're multinational companies that have certain commitments. They have permits with certain requirements on them that don't change overnight. And so there are the state implementation plan regulations that don't change overnight. So although there may be, within the Beltway, a lot of excitement about what's happening in Washington and what the new administration may do, any changes that occur are going to occur slowly. And it's like a big ocean liner in a way. Environmental regulations aren't going to change overnight. There may be a slowdown of activity. It may be that some of these regulations will pause for a bit. For example, the automobile standards, there was a long, and also the Clean Power Plan, there are long compliance dates in those statutes. They were ambitious, but you're talking about decades before ultimate achievement. So what happens in the next 4 years may be something that would, on a short-term basis, affect the trajectory, but on a long-term basis, it's anybody's guess. There's an interesting remark by Winston Churchill, who said that Americans can always be counted on to do the right thing after exhausting every other possibility. And perhaps you have to accept sort of a long view of environmental law. I think I'm an optimist. I think that these issues are important, and they're things that ultimately people will decide we must do.
Yeah. You've had an abiding interest in science and the law-science interface, and we've now, I think this is probably our third transition running, in which the new administration is accusing the prior administration of junk science, so-called junk science. And I guess the question for you is, how difficult is our situation when it comes to consensus about kind of basic science as it relates to the environment, and how do we find ourselves to a place where scientific fact itself is not the subject of such intense disagreement and dispute?
You've put your finger on something that I think is a real problem. I think that there's a lot of public confusion on issues. You can recall not only scientific issues, but ordinary factual issues. Look at the polls that were taken years after the Iraq War, where a pretty healthy fraction of the country still believed that there were weapons of mass destruction, when it was clear that everybody proved that we're not. The National Academy of Sciences had some salutary impact on trying to help the debate on some of these issues, but it's very problematic because I don't think that the public understands scientific issues. They sort of react to what they see on television, which often is confusing and contradictory. It would be very valuable and very important if perhaps scientists and the media and other people with access to the public could engage in much more public discourse on these issues, because ultimately I think an informed public will make much better decisions, and you see very little of that. I mean, I read religiously Science magazine and the science sections of the Post and the Times and other publications, but I think most people don't have that information, and if they're told things by various media outlets that are untrue, or that they don't need to worry about certain things, that climate change, for example, is a hoax, that's unfortunate, because it misses an opportunity to engage in debate about these issues and decision making as to what ought to be done. I remember hearing Elliot Richardson speak about 20 years ago. He talked at a meeting that I was at, presenting slides and information about climate change, and made the point that if something isn't done now, that a generation or two later, people are going to look back and say, what were these people thinking? Why weren't they taking action? And I hope that doesn't come true, and that there's still some time to deal with these issues. That's not to say that it's easy, but you need an informed public and an informed public debate to decide, to agree on scientific facts and to make policy judgments as to what the response should be.
In addition to climate change, are there other kind of big unsettled or unresolved questions in the environmental space that you hope either our generation will get around to, or that the upcoming generation of environmental practitioners will approach with the seriousness that they deserve?
There are a number of them. There are certain sort of intractable problems. For example, in the water area, the low-hanging fruit has been addressed. Companies with direct discharges get permits and that are reviewed and dealt with, but you've got the perennial issues of non-point source discharges from farms and other sources. You also have municipal treatment works discharges that have combined storm and wastewater overflows that release untreated sewage. I'm representing a client called Blue Water Baltimore that has intervened in a lawsuit in Baltimore involving the city water system, dealing with those kinds of issues, and it's one of I expect a number of around the country. So that's an intractable issue, and municipalities and farmers are parties that regulatory agencies tend to be gentle with, but the public is impacted, and at some point some solutions need to be found. Superfund is another area that I think has been difficult. One of the mistakes that I think was made in the early days of Superfund is that the EPA decided that you needed to have a perfect remedy. And as a result, there was a lot of paralysis, and it took years of study and analysis to decide on a remedy, the result of which that it took a long time for decisions to be made, and it was a very costly process. I think back to the early days of the NPDES permit program, where Congress told EPA that you had to regulate discharges and establish best technology requirements. And EPA and everyone realized that it would take years for those regulations to be put in place. In the meantime, people needed permits. And so what EPA did is to give permit writers the authority to use best professional judgment. And judgments were made, and life went on, and permits were written, and companies installed controls. And the understanding was that you get a permit for 5 years, and every 5 years you go back and look at the situation and see if it could be improved. And I always think that if the Superfund process had started in that direction, that you would have had a lot of work done very quickly. You'd get all the low-hanging fruit, and you could come back and decide whether there was new technology or problems that hadn't been addressed before that could be dealt with. Instead, you have paralysis, you have lots of committees, and people adopt kind of a litigation mode because the fear is that the worst is going to occur. I think that more creative thinking and perhaps a little bit more flexibility in decision making could be a good thing.
Okay. Well, that brings me to the end of the prepared questions. Is there anything that we haven't covered that you'd like to add to our conversation?
In terms of a couple of things that surprised me about the way environmental law developed, I always thought that it was odd that the Clean Water Act and the Clean Air Act developed in such different directions. When the Air Act was established, the focus was on ambient air quality. There was no permit program. Instead, you had ambient air limits that would be enforced by states in implementation plans. And it took decades for people to finally get around to the idea that, gee, maybe everybody ought to have a permit for air emissions. The Clean Water Act was almost a mirror image for perhaps historical reasons, going all the way back to Calur versus Rezer, which you may remember. There was a district court decision suggesting that under the 1899 Refuse Act, and this was a surprise to everybody, that discharges without a permit might be unlawful. And so Congress and industry were very alarmed by that and said, by God, we're going to have a permit program. And so they did. But there were provisions in the Clean Water Act of '72 for water quality standards, but that was sort of very slow to develop. But instead you had a very rigorous permit program where everybody needed to get permits, and there were controls on industrial sources, and gradually tightening controls over the years. But I always thought it was sort of interesting that those two major statutory provisions developed in such different ways. Another thing that I found sort of odd and disappointing, I referred to earlier, is the definition of waters of the United States. This is a 1972 statute, and waters of the United States is sort of a bedrock jurisdictional definition. I mean, you don't regulate any discharge to waters unless it's a jurisdictional water, unless it's a water of the United States. And here we are in 2017, and we don't know what a water of the United States is. You had the Rapanos decision with a 4-4-1 split with two different notions. of what a water of the United States is, and a lot of interesting discussion among scholars as to whether when you have a 4-4-1 split, whether it's the least restrictive decision or opinion that's necessary to for the result that controls, or whether it's the fifth vote that governs. And so that goes on, and maybe the Supreme Court ultimately is going to have to resolve it, perhaps by giving us better guidance. But it's unfortunate that occurred, and that confusion actually, I think, was partly responsible for the Sackett line of cases, where EPA, I happen to be involved in the Supreme Court Sackett case, and the Sacketts filled some property out west to build a house, and they were told by the Corps of Engineers that it was unlawful because there was a wetland there. They took the position that nobody in their area that had built houses had ever been told that there were wetlands there. So EPA issued a compliance order with penalties of $37,500 a day if they didn't fill in that wetland. And so they went to court saying, we want a court to decide whether this is a wetland or not. Do we need a permit? EPA took the position that you don't get judicial review. You can wait until we sue you, or you can comply, but you don't get judicial review. It went all the way up to the Supreme Court, and the Supreme Court said you can't put somebody in that position either being forced to give up your legal rights or running those kinds of penalties. But I think that both the majority and Justice Alito's concurring opinion alluded to the confusion over waters of the United States, as saying that, gee, people really don't know what they need to do to comply with the law, and to say to people that you have to wait until you're sued is really inappropriate. And I think both opinions, I know that Alito's said that Congress really needs to provide some guidance. Well, the EPA has provided guidance, but Congress hasn't. And I think it's unfortunate there, and I think it's unfortunate that with respect to climate change, that Congress has been silent. EPA has been left to deal with the issue. Massachusetts versus EPA, and the Supreme Court said that EPA does have authority to deal with the issue in general, but it would be helpful if Congress provided guidance as to the specifics, as to how do you do it, and make those kinds of policy judgments. It would make EPA's job a lot easier, and perhaps less controversial.
Do you think there's any hope for a return to a bipartisan approach to these vexing issues that remain, like climate change and jurisdictional waters?
I'm not alone in saying, among many other political commentators, that that's one of the most unfortunate aspects of our country's sort of political life now, is the polarization. Members of Congress lament it, and commentators and people in the public lament it, because you and I remember back in the day, there were conservative Democrats, there were liberal Democrats, there were conservative Republicans, and there were liberal Republicans. And congressmen stayed in Washington. They didn't run home on weekends, and they would have dinner together and work out issues. Ronald Reagan famously said that if somebody votes my way 70% of the time, or agrees with me 70% of the time, he's my friend. It's unfortunate now that the atmosphere seems to be that you have to be with me 100% of the time. I hope that that will change. I like to be an optimist. I think ultimately change is going to come from public education and people voting at the polls.
Well, thank you, Ted. Thanks so much for your pioneering work, your continuing leadership in the field of environmental law, and for your participation in this interview.
Thank you.